Hello, I'm Dana Sparks, Managing Broker of Maximum One Greater Atlanta. And today's contract tip has to do with the holder of the earnest money. As an agent, when you are drafting a contract, the buyer and the seller have a choice to put down in the contract who is to be the holder of the earnest money. Typically, it is one of the brokers, either the buyer's broker or the listing broker. Many times, however, lately we are seeing a closing attorney as the holder of the earnest money. Now, in certain situations, typically with an REO property, the attorney must be the holder of the earnest money. But as an agent, when you are drafting a contract, if you have the choice as to which party to put down to be the holder of the earnest money, one or the other broker or the closing attorney, just a couple of thoughts to think about before you put down the attorney to hold the earnest money. As a holder of the earnest money, there are many responsibilities outlined in the contract that the holder must fulfill. Number one, the holder is to receive the earnest money from the buyer, obviously. Number two, the holder has a certain time frame within which to deposit the earnest money into an escrow trust account. And those timeframes are clearly outlined in both the Georgia Association of Realtors contract form and in the RE contract form. Those timeframes are different, but they are already spelled out, pre-printed regarding the time frame, the number of banking days for the holder to deposit the earnest money. Three, if the holder of the earnest money does not receive the funds and does not make that deposit, or receives the funds, makes the deposit, but the bank does not honor those funds, the holder is required in the contract to give notice to the buyer and the seller that they either never received the funds or they weren't honored by the bank. At that point, the buyer has the option of making those funds good. And again, all of this and the time frames are clearly spelled out in the contract. And if that does not happen, then the seller may terminate the contract. In our market right now, with multiple offers and backup offers higher than where a seller is currently under contract, very, very attractive offer for a seller to contractually terminate a contract in favor of a backup one. So again, the holder of the earnest money has this responsibility to give notice if they don't receive the earnest money. One of the other responsibilities of the holder of the earnest money is if the contract terminates by one of the other parties and there is no agreement between the buyer and the seller as to who gets the earnest money upon termination, then the holder, one of the options that the holder has is to go through the contract, make an interpretation of the contract and the reason it failed to close or the reason it terminated, decide which party defaulted on the contract, which party the holder is to disperse the earnest money to as liquidated damages, send out that notice, which is typically referred to as the 10-day letter. And then after the notice is given and the time frame is passed without any objection to that, then disperse the funds as noted in the notice. One of the other options upon dispute of earnest money with a terminated contract is the holder also has the option of interpleading those funds into the registry of the court, which involves filing a motion into the court. It involves time, energy, effort, and money. So typically, brokers, whether it be a buyer's broker or a listing broker, is typically the holder of the earnest money. And as brokers, we are very well aware of our responsibilities with respect to the earnest money as outlined in the contract in terms of when it should be deposited, keeping track of those time frames, giving the proper notices if the deposit is not made or if the check bounces from the bank, and then also doing the interpretation if there is a disagreement on the disbursement of the earnest money upon termination or filing an interpleader motion into the court. Additionally, as an affiliated licensee representing the broker, when you as the licensee sign that contract, you are signing on behalf of the broker, giving the broker's agreement to fulfill those responsibilities as holder of the earnest money, based if that is what is filled in, which party is to hold the earnest money. If you put in a closing attorney to hold the earnest money, a closing attorney never signs the contract. A closing attorney does not by default agree to the responsibilities to be the holder of the earnest money and fulfill the responsibilities or the duties as outlined in the contract, as I just spoke about. So, a couple of issues. If you do put in an attorney, a closing attorney, to hold the earnest money, number one, make sure before you go binding that the closing attorney agrees to hold the earnest money and that the closing attorney will fulfill those responsibilities as outlined in the contract should there be some issues with the earnest money. Number two, you need to make sure that after you do go binding, the closing attorney gets a copy of the contract so they know what their responsibilities are and the time frames. Number three, make sure the closing attorney does know the proper time frames, does know based on the binding agreement date when the earnest money is to be deposited, and has all the proper contact information for the parties to give notice should the buyer never remit the funds or should the funds not be honored by the bank. Additionally, if there is a termination and disagreement on the earnest money, as discussed, the holder makes sure the closing attorney is willing to go through, take the time to go through, interpret the contract, and send that proper, the 10-day notice, the 10-day letter as well regarding that. Just a couple of issues that have happened to bring your attention to why this is such a key, important factor as you are drafting a contract, and to give this consideration. Don't simply just fill in the blank. What happens if the parties, the buyer and the seller, agree because the agents have written in the attorney as the holder of the earnest money without consulting the attorney first, so the attorney never gave their agreement to fulfill the responsibilities as the holder of the earnest money. Buyer never remitted the funds. Attorney didn't know they were the holder, so they never gave notice to the buyer and the seller that the funds were never remitted and therefore never deposited. Then the buyer defaults on the contract, get a termination and release agreement. Let's just say the buyer admits that the buyer defaulted on the contract. In the release agreement, signs that the seller, sure, go ahead, have the earnest money as liquidated damages based on the buyer's default. Send that over to the closing attorney so they can disperse the funds to the seller. Closing attorney says, what are you talking about? I don't have the earnest money. I never got it. Buyer and seller and agent say, well, you never gave the notice that you didn't have it. So therefore, aren't you responsible for making good on those funds since you didn't give the proper notice? Closing attorney could say, I never agreed to be holder of the earnest money. I never agreed to those responsibilities. It wasn't necessarily my responsibility to give that notice as holder because I didn't sign the contract on behalf of a broker. Potentially, you could have some major problems on your hand. So not all closing attorneys will not agree to be holder of the earnest money and will not fulfill their contractual obligations as holder of the earnest money. But for you as an agent, you need to be keenly aware of what is involved and don't simply fill in the blanks in a contract. Make sure prior to drafting a contract, prior to going binding on a contract, that the closing attorney does agree to be the holder, agree to send out the proper notices, agree to keep track of the time frames, and basically agree to fulfill the responsibilities as outlined in both the Georgia Association of Realtor contracts and the RE Forms contracts as the holder of the earnest money and those responsibilities as outlined. Again, Dana Sparks, Managing Broker of Maximum One Greater Atlanta. Thank you so much for watching, and I hope you enjoyed this week's contract tip.